It is now time, and we have formed a quorum. I declare that the meeting of the panel on administration of justice and legal services will start now. This meeting is conducted on Zoom this time. We will begin now. First of all, there are some matters that I need to talk to you. First of all, members, please note that now when we speak in the meeting, we must switch on our video function to show your face. And under my instruction, your mics will be switched on. And if you would like to listen to simultaneous interpretation, then please press the interpretation function on the Zoom panel and choose your preferred language. You will then get interpretation. In order to be more orderly and fair and allow members to speak in an orderly way, before we start, I will first ask our colleagues to clear the raise hand button signs first. Please push raise hand button again. I will invite you to speak according to the order. So this meeting is conducted entirely remotely. So 30 seconds before the end of your time limit, our helpers will display a countdown on the Zoom screen. And then when your time is up, then the timer will alert you to stop. And then I will instruct you to stop speaking. Members who participate in this video conference have to use backgrounds of 3 different colors, either one of them. I guess you are familiar. If you have any questions, please send messages to our secretariat on Zoom. During the meeting, if members would like to submit papers, please send the papers to the email account of this panel. Now we will begin this meeting. Agenda item 1, information paper issued since the last meeting. Members, please note that since 27th September 2021, after our regular meeting, we have received 5 information papers, including submissions from Mr. Yim Kong and Dr. Simon Lee on 2 legislative proposals of the administration, and also the administration's response. Paper numbers are CB bracket 4181/2022 bracket 01 bracket 02 and bracket 03. Apart from these 3 papers, recently we received 2 letters from members to this panel. The first is from Mr. Lam Chun Keung, dated 25th March this year. It is a letter from him asking for a discussion of restarting the bill on parent responsibilities. So I have already asked the Secretariat to circulate that letter to members. We will ask the DOJ for response, and then we will handle it. And then just before the start of this meeting, I received from Ms. Leung Mei Fun a letter. It is about the item that we are going to discuss today. And it is a written submission on Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Bill and Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Rules. As Ms. Leung's letter is related to today's agenda item, so I would ask the Secretariat to circulate that letter to you. So based on these information papers, let's see whether members have questions. Mr. Tommy Zhang. Please unmute Mr. Zhang. Chairman, sorry. Actually, I would like to speak on item number 3, so I have just wrongly pressed the button. Okay. Members, if you don't have any further question, then let's move on to agenda item 2. Item 2, items for discussion at the next meeting. So now I would like to report to you that I, together with the Deputy Chairman, on 18th February this year, had a discussion with the government and the administration wing of the judiciary. We talked about work plan of this panel for the year 2022, and after considering the administration's recommendation and also members' views, we have set out this list of outstanding items for discussion. I believe you have got that paper. So please refer to paper number CB bracket 4 192/2022 bracket 01. So any questions on this list? Mr. Lam Zhangkang, please. Thank you, Chairman. Chairman, I hope to add one more item, which is important to the legal sector, and that is incorporation of solicitors' practice. So for a number of times, I said to DOJ and the relevant persons about this. I hope to include that item into this list of outstanding items for discussion for this year. Thank you. Thank you, Mr. Lam. Ms. Kan, Ms. Carmen Kan. Chairman, in this list of outstanding items, if I have suggestions to amend wording, so what should I do? You can raise your point now and our secretariat can take note of it and make necessary amendments. Okay, yes, item 13. Item 13, in the description. So there are 3 members, Ms. Maggie Chan, Mr. Holden Chow, and Ms. Carmen Kan expressed concerns about the trainings provided to judges and judicial officers and legal officers on the constitution of the PRC and so on. There's no problem here. And then para 2, no problem with Mr. Chow's description. And then Ms. Kan was concerned whether, and all the way to full stop. So the content is related to Ms. Maggie Chan's concern. So this should be Ms. Maggie Chan's concern. Okay, right. Thank you. Secretariat, can you please take note of it and make necessary amendments? Any other questions or comments? If not, then let me report to you. On the 25th April meeting, we will discuss 2 items proposed by the administration. First, report on Hong Kong Legal Week 2021. And then number 2, promoting and facilitating wider use of law tech. So a number of members proposed this item. They would like to discuss this item within this legislative year. Please take note. So colleagues, if you have any further questions or comments on this arrangement, if not, then we will move on to today's agenda proper. No comments? Okay. Agenda item 3, arbitration and legal practitioners legislation, outcome-related fee structures for arbitration amendment bill 2022. Now we have invited members of this panel to join and also non-panel members to join because this is related to legislative proposal. Okay, so now let me invite government representatives and representatives of the 2 legal associations to switch on your camera on Zoom, and then I will introduce representatives in attendance today. For this item, we have from Department of Justice, Deputy Law Officer Civil Law, Mr. Clifford Tavares, and Senior Assistant Law Officer Civil Law Arbitration Acting, Ms. Venus Zhang, and also Senior Government Counsel, Ms. Helen Tang. Besides, we also have from the outcome-related fee structures for arbitration subcommittee of the Law Reform Commission of Hong Kong, co-chair Ms. Catherine Sanger, Mr. C.M. Chan, and Mr. Benny Low. From Hong Kong Bar Association, we have Mr. Victor Dawes, Mr. Jose Antonio Morales, Mr. Richard Kaur, and Ms. Kim Rooney. From the Law Society of Hong Kong, Mr. Robert C. Roda, member of Arbitration Committee, and Mr. Eric Wu, member of Arbitration Committee. Okay, so colleagues, can you please clear the raise hand functions or signals already invoked, and then I will later on ask members to use the function later if necessary. Right, so if you'd like to speak later, please press the raise hand button now. Okay, so I will first ask the administration to go through the paper, and then I will invite representatives from the two Law Society and Bar Association to speak, and followed by members' remarks. First, administration representative, please take us through the paper. Now, we have quite many agenda items today and time is tight, so we would like to ask the government to be concise. Please do not use more than 10 minutes, okay? Thank you. Thank you, Chairman.
政府將於2022年3月30日
On 30th March 2022, the administration is going to table to the LegCo Arbitration and Legal Practitioners Legislation Outcome-Related Fee Structures for Arbitration Amendment Bill 2022. The goal is to amend the Arbitration Ordinance and Legal Practitioners Ordinance to remove the restriction on outcome-related fee structure. So the amendment is in accordance with Law Reform Commission report on outcome-related fee structures for arbitration published in December last year. Now, if you refer to common law provisions in relation to champerty, maintenance, and barratry, fee structure is being prohibited. Besides, in arbitration, lawyers are not allowed to offer any financial assistance or subsidy. And then, according to the bill, 3 types of fee structures will be allowed. Number 3, condition-based. So the lawyers and the litigants will have an arrangement that if the case is successful, the lawyers can charge additional success fee with an upper limit of 100%. And then second, damages-based agreement. So the two parties agree that the lawyers will charge this fee if the litigant is able to enjoy some financial benefits. So this DBA has an upper limit of 50% of the financial benefit payable to the litigant. Number 3, a hybrid DBA format. So for legal services provided, the lawyers will charge a fee, and usually there would be a discounted rate applied. And then if the litigants can get financial benefits in the case, then the lawyer will add a surcharge based on the damages. Again, the upper limit will be in place. Of course, it is the cornerstone of arbitration for two sides to have autonomy, and then the options should be in line with the above principles. Besides, the suggested mechanism will make sure that there would be enough safeguards to protect the user of this fee structure, to guard against dishonesty and abuse. And then the proposed law reform will bring many benefits to users. For lawyers, for litigants' lawyers, the autonomy of the fee structure and flexibility is huge. So based on conditions, there can be the best fee structure as agreed. Very often, the litigants are very clever businessmen. So with this fee structure, the people's need for flexibility in the market can be satisfied. For those who don't have enough funds and who can't provide enough justifications, then there is another way for justice to be administered. And then the fee structure can allow legal practitioners to offer competitive service conditions. Up till now, in many other main jurisdictions or arbitral seats, to a certain extent, this type of fee structure is allowed, and in Hong Kong, if we introduce this into Hong Kong, we can keep pace with time, and we can maintain our competitiveness as a major international arbitral seat. So that's why the administration agrees to the LRC's suggestion to amend the Arbitration Ordinance, Legal Practitioners Ordinance, and the Law Society Code of Practice and Code of Practice of Bar Association to put in place ORSF. Besides, we agree with LRC that detailed mechanism and safeguards should be listed in the subsidiary legislation. So safeguards include a number of things. For example, in principle, how should this fee structure be set out on the fee amounts, there should be appropriate limits, upper limits. Besides, what are the requirements for this fee structure? Should it be in writing? And then the parties should sign it. And then the lawyers should tell the parties that they have the right to get independent legal advice. And then for the fee structure, there should be at least 7-day cooling off period. Besides, for the fee structure, there should be clear setting out of all the conditions. For example, under what circumstances the lawyers' expenses and costs have to be paid, and for the lawyers and the parties, do they have the rights that before the termination of the arbitration, the fee structure can be terminated, or under what circumstances can the fee structure be terminated?
And further, this is only relevant to the legal proceedings of Hong Kong, and it is recommended that it should not be made relevant to certain other legal processes, including those for personal injuries. So this is my briefing, and the Law Reform Commission representatives can also guide us through certain content. Well, thank you very much. We have the two professional bodies with us. First of all, the barristers. Mr. Would you want to speak from the Bar Association? Mr. Victor Dawes. Now, because of the interest of time, we may have to be succinct, and your written submissions have already been circulated to the members. Yes, Mr. Dawes, please. Well, thank you very much. Concerning this particular topic, we have already provided our views to the LRC. And today, I will basically just ask my colleague to go through some of the points in brief.
No. Thank you. Hong Kong is one of the world's leading international arbitration centres. The Bar generally supports the reforms recommended by the Law Reform Commission after consultation with the public and adopted by the government that, firstly, Hong Kong law be amended to permit outcome-related fee structures, ORFS, in commercial arbitration taking place in Hong Kong, which are in the nature of conditional fees and contingency fees that a party agrees with their lawyer with appropriate safeguards in the public interest. Secondly, that Hong Kong law and it follows be reformed to allow a written agreement between a lawyer and client as to contingency or success fees or a hybrid if these proceedings are successful within the meaning of the agreement, once again, provided that appropriate safeguards are put in place. Thirdly, that personal injury should be excluded. The Bar made a detailed response dated 6 July 2021 to the recommendations in the December 2020 consultation paper of the Law Reform Commission's ORFS subcommittee. The Bar considers that these reforms are needed as essential for Hong Kong as an international legal services centre to ensure that Hong Kong's arbitration framework continues to reflect international best practices, that Hong Kong's attractiveness and competitiveness as an international arbitration centre, both of these are preserved and promoted, that there is access to justice supported by a party being able to have their case funded by their lawyer with appropriate safeguards, and that members of Hong Kong's legal profession, including barristers, should be able to offer fee structures similar to those that their competitors in other jurisdictions can already offer. Various forms of contingency and success fees have already been successfully implemented in many jurisdictions, including England and Wales and Australia, which both have an independent referral bar, as well as in mainland China and the USA, among other jurisdictions. The Bar's Code of Conduct already allows a practicing barrister in relation to legal services provided outside Hong Kong to work on a contingency fee basis, provided contingency fees are lawful in such jurisdiction. However, as you know, the position for arbitrations taking place in Hong Kong and related work is otherwise. The bar does consider it's in the public interest that safeguards for financial and ethical matters be applied to provision of funding by lawyers wherever located. The bar suggests that the areas that be covered are along the lines in the Code of Practice for third-party funding of arbitration. The bar does look forward to consulting with the Department of Justice, the advisory committee to be established, the Law Society and other stakeholders concerning the rules that will set out the ethical and financial safeguards. It also notes that provision has been made for a code if needed. Finally, the bar's code of conduct provides that a fundamental characteristic of serving as a barrister is that the barrister is bound by the cab rank rule. As you know, this requires a barrister to accept any brief to appear before a court or similar if the barrister has the expertise, capacity, time, and the fee is proper. However, the perception of a conflict may arise if a barrister receives an outcome-related fee, as he or she will have a pecuniary interest in the outcome of the arbitration. And this is an area that we consider, that we, the bar, consider we need to address when the bar code is revised, if these reforms go through, to make it clear that work compensated by an ORFS will be an exception to the cab rank rule, as indeed the English bar has done. We thank you very much for the chance to make these comments, and of course we're happy to respond to any questions that you may put to us. Thank you.
And next we will have Mr. Huda to give us the Law Society of Hong Kong's views. In fact, we have already received your written submission. The Law Society of Hong Kong, please.
Thank you very much and good afternoon. I'm going to use up just 2 minutes of time, I believe, followed by Mr. Wu, also from the Law Society. First of all, let me say that the Law Society very much supports the policy direction of the amendment bill. The ability to enter into outcome-related fee structures is important in ensuring that Hong Kong lawyers can continue to compete internationally for Hong Kong and overseas arbitration work, because sophisticated clients increasingly demand them and our competitors increasingly allow them. It has become the norm in other major arbitration hubs. The Law Society welcomes the express provision in the draft bill that the common law offences and torts of maintenance and champity do not apply to outcome-related fee structures for arbitration in and outside Hong Kong. The Law Society supports the exclusion of ORFS agreements relating to personal injury claims from the draft amendments. And finally, the Law Society looks forward in due course to being consulted on the rules and code of practice referred to in divisions 5 and 6 respectively of the draft bill. We anticipate that the rules will contain provisions on, for example, the appropriate level of any caps on the success fees for conditional fee arrangements and for DBA payments. Thank you.
Yes, thank you, Chair. Yes, Mr. Eric Wu. Indeed, as Robert had mentioned, we are in principle in support of the ORFS arrangement because it allows Hong Kong legal professionals to greatly enhance our competitiveness, and in particular in arbitration, the two parties will set the seat of arbitration. And with the ORFS in place, we believe, and that is the Law Society of Hong Kong believes, that the two parties would be more willing to use Hong Kong as the seat of arbitration so that Hong Kong will further become an international arbitration center. Now, in terms of details, the Law Society is in support of CFA, DBA, and hybrid DBA. And in our written submission, we have also said that there is just one point of supplement, though, and that is for DBA and hybrid DBA, the Law Society of Hong Kong hopes that there can be a lower success fee cap. But as far as we know, the LRC is suggesting a 50% cap. And we are in principle in agreement with that, but our view is that a lower cap would be more attractive to the clients. And so this is a point of specific, and we will continue to hear the discussions on this and other points. Yes, we will have the Q&A time. We have 5 members who have indicated that they want to ask questions, and they are Mr. Tommy Chung, Mr. Holden Chow, Ms. Leung, Ken Weiman, and Liu Cheng Kong, and then Ms. Kong. 4 minutes each, including Q&A. Mr. Tommy Chung first. Thank you, Mr. Chair. Concerning our party, concerning this particular amendment, in the amendment bill, we do not have strong views. We have always been supportive, as you know, the development of Hong Kong as an international arbitration center. And so this is in keeping with this particular direction, even though not all jurisdictions or countries actually have put this into practice. But for our competitors in the common law jurisdictions, if they are adopting this, we must not lag behind. But what I'm concerned or worried about is, well, concerning this particular amendment bill, in its consultation, I have heard that the Chambers of Commerce had been consulted. Now, did we consult the legal department of the chamber, or was it the members of the Chambers of Commerce? Because this is about fees for the lawyers. Well, I hope in the next round of consultation, whether it is a government or the LegCo, that we invite more major companies and chambers of commerce. Well, I'm not worried that the cafes or the cha-chantings in Hong Kong but would go into arbitration a lot. But on the other hand, there are some major chains or groups in my constituency which may be affected. Even though I do not foresee a lot of problems on their side, I'm just saying that in the next round of consultation, I understand and I have noted that this is not about class actions, etc. This is really just about arbitration. It is about the fee for arbitration. So what I'm saying is that in the drafting of the bill and in the consultation, we can include the consultation of companies and corporations which may be using the arbitration and whether they have any views on this. And I hope the major chambers of commerce, they can be consulted and they in turn can ask their members or companies concerned. Thank you. Mr. Chung, do you want the government to respond to your question? Is there any
主席，多謝議員嘅意見嘅。其實睇翻咧，法改會今次嗰個報告出之前咧，其實都有一個3個月嘅公眾諮詢，咁都收咗20幾份嘅回應翻嚟嘅。咁其中咧係會有唔同嘅界別啦，包括有香港總商會啊，亦都有 Consumer Council 啊咁，所以其實都係一個經過廣泛諮詢之後即出嚟嘅一個報告。咁當然個報告之後咧，其實當律政司再去研究個報告嘅時候咧，其實有再去諮詢呢個仲裁推廣諮詢委員會嘅。咁當然喺嗰度咧，亦都有唔同界別嘅人士喺度，當然包括 legal sectors 啦，咁亦都另外其他界別嘅。咁所以總體咧，其實個諮詢咧都係有一個基礎喺度。咁但係當然明白喺往後如果我哋做譬如 保障措施嘅時候，做啲附屬法例嘅時候，嗰陣時當然喺諮詢嘅時候咧，我哋亦都會再多加留意嚇。唔該，主席。
Thank you. Next, Mr. Holden Chow. Thank you, Chairman. Am I coming through okay? Yes. Okay, thank you. My comments are, number one, concerning arbitration, the use of outcome-related fee structure in arbitration, I am in agreement. As the administration just said, for other jurisdictions or our competitors in other jurisdictions, if they adopt similar way, then we want to enhance the competitiveness of our legal profession, then I agree to the use of this approach. But my main point is, this time, I hope the government can clarify. So this time we are working on arbitration, and within the scope of arbitration, personal injuries claims will not be included. So in other words, outcome-related fee structure can only be applied with the exception of personal injuries claims. So I want to clarify this point. I don't want people to misunderstand that if this fee arrangement or this fee structure is put in place, then in the future, it will be applied to other types of litigations. So I want to say that outcome-related fee structure in the legal profession has long been discussed. And we cannot come to a conclusion immediately whether I am in agreement or not. But then this time, the government has the responsibility to tell people clearly that this only applies to arbitration. So they will not immediately open the door for other types of litigations. So if that has to be done, I think we need a very detailed consultation, and we need to listen to the public very clearly. There should be some more exploration because outcome-related fee structure is being adopted in many common law jurisdictions, but there are both pros and cons. Now, there may be the big increase in a number of litigation cases. Let's say if one day we allow civil proceedings to adopt this kind of fee structure, then we need to think whether personal injuries claims or cases should be included. Because in personal injuries cases, people's negligence and also claims, if this kind of fee structure is allowed, then there will be some risk. Will there be some misleading situations? I think we need to be very careful. So I hope the administration to take this opportunity to explain very clearly to this panel on points I raised. So this is my main opinion. Thank you. Okay. Thank you, Chairman.
多謝議員嘅意見。係首先第一，我確認咧就係冇錯，今次嘅修訂咧只係即係關於呢一個仲裁方面嘅啫。而政府喺研究之後咧，而家係冇任何嘅打算咧係去再研究係咪 extend 去即係埋 litigation 咁樣嘅。咁第二咧亦都係認同議員嘅意見咧，就係其實呢個係一個要好即係深入去再研究嘅一個議題。或者我提供一個簡單嘅資料就係其實法改會咧喺2002年嘅時候咧就住呢一個外傳收費咧都已經有個諮詢，07年出咗個報告。當時諗緊嘅咧係話可唔可以喺一般法律程序，即係唔係淨係限於仲裁都用呢一個外傳收費。總之啲簡單講咧，當時其實覺得咧整體咧唔係一個時候去處理。咁只不過而家法改會做呢一個報告嘅時候咧，睇翻喺仲裁方面咧嗰啲。Put together the report.
Right now, in the case of arbitration, the concerns back then were already outdated. And outcome-related fee structure can be used for arbitration. So this time, only arbitration. In the future, if it has to be extended to litigation, then there's the need for consultation and more in-depth studies. Even though this structure is put in place in other jurisdictions, we need to know whether it is appropriate in Hong Kong and whether it is the right timing. Okay, 3 more members would like to speak. Ms. Carmen Kan, Ms. Kong Yok Foon, and Mr. Lam Sun Kang. So Ms. Kan, please. Thank you, Chairman. We understand that when the administration presents this bill on outcome-related fee structure, the purpose is to enable Hong Kong to exercise or realize a bigger strength as an international arbitration center. We have heard that the Law Society and Bar Association in principle are in support. So I want to ask the DOJ or LRC whether analysis or projections have been done on other common law jurisdictions if they adopt ORFS. Then concerning choice of dispute resolution method, has there been any change? So is it true that there are many more arbitration? Has there been more problem in relation to the impact on Hong Kong? Now, for arbitral seats, we do understand that Hong Kong as an arbitral seat is well prepared. So I want to know from the two professional bodies, when we work on arbitration, in terms of the readiness of our talents, what is the response? Just now, I heard from Bar Association that in relation to the code of practice, well, there is some preparation, but in terms of the talent pool, our ability in arbitration, well, I don't think it is totally the same, right? So that's my second question, Chairman. Thank you. So, okay, two questions. DOJ and LRC, and then I will ask the two professional bodies to comment. Okay, first, LRC.
我再答先，然後可能要麻煩即係法改會嘅
Let me answer the
member 都可以
question
再補
first,
充。
and then I will invite LRC member to
係，多謝
supplement.
議員嘅提問。
Okay, thank you.
當然喺呢一個法改會研究呢
For
一
the
個
question,
議題嘅時候，
when LRC
做
looks
個報告
into
嘅時
this
候咧，其實
matter,
係有
when
睇
a
到其
report
他
is published,
地方嘅做法啦。
other
咁包括係
jurisdictions approach
中
has
國內
been
地啦、
looked into,
新加
including
坡啦、
mainland China, Singapore,
英國啦同埋澳洲嘅。
UK and
咁
Australia.
其中一個即係 study 呢一啲地方嘅情況嘅嗰個 focus 咧，就係睇下
The focus
容
of
許咗
doing
呢一
these
個
overseas studies
收費架構之後，會唔會有一啲即係不良嘅影響啊？可能係
is about whether there are any adverse
咁
impacts
咁發覺
or
咧，其實冇呢
misconduct
啲
of
明顯嘅跡
lawyers.
象咧，就以至到
And
覺得咧，其
there
實
is
係
no
可以
clear
係運作
signal
順暢嘅。咁所以喺香
of
港嚟講，
problems. So
好咧。
in Hong Kong,
咁如果你話有冇一個 impact， 有冇一個實際數
if you
字話
ask
喺嗰
whether
啲
there
地
is
方，
impact
因為有
or
咗呢一個
specific data
OFSA， 就
as to
會多咗訴訟咧，就
whether there are more
我就
litigations
睇
with
落個報
OFSA
告咧
in
係
other
冇特
places,
別
well,
有
reading
呢一
from the
個
report,
數，即係有
there
做到呢一
is
個統計
no
呢個數字嘅。
such
咁但係我諗當然
problem or
正常嚟
statistics.
講就應該係會
So
多可能係會多咗，因為
normally
正正就
speaking,
係
there
呢樣
should
嘢
be
就希
more
望俾多一
because
個option 一個
we
financial
just want to
option 俾啲
allow
clients 同
one
埋律
more
師。
option
咁其中一個好處
to
就係無
clients
論
and
喺香港或者其
lawyers.
他地方都係，
So
譬如
in
有
Hong
一
Kong
啲
and in other places,
當事人佢本來冇錢，咁但係
if
因為
a
想
certain
即刻有 claim
party,
佢
if
冇
a
錢，咁但係如果
litigant
多啲
doesn't
嘅選
have
擇咧，可能
money,
有律師幫到
if
佢
there
啦。
is one
咁無
more
論對個當
option,
事人佢可以
then
做到
lawyers
個
can
claim，
help
又或者個律師其實
that
一啲唔
person
係一個好大嘅
in
律
making
師
a
行，
claim.
佢可能
Or
借呢個
if the
機會
law
咧
firm
可以
is
進入
not
個
a
市
big
場。
one,
咁所以 一
then
定係
it
一
can
定
take the
係會
opportunity to get
理論
into
上
the
多咗。咁
market.
但係個實際
So
嘅數字
theoretically
喺其
speaking,
他
there
地
should
方，
be
我
more.
喺呢度
But
就
if you
即
ask
係
for
一個
the
報告應
exact
該係
number
冇
in
特
other
別有，或者可唔可以
jurisdictions,
麻煩法
it
改
is
會
not
嘅
included in the
委
report.
員有冇其他
Perhaps
補
I
充？
will
唔該。
ask LRC colleagues to see whether they can supplement. Right, I don't have much to add because of time constraints.
I think just two very quick points. I'm not sure there's been any analysis done on whether cases in other jurisdictions have increased because of the ability to offer success fees. But it's very clear that the choice for parties of where to seat international arbitration is increasingly very competitive, and Singapore is probably the only other jurisdiction as a leading arbitration seat which doesn't yet offer success fees but is also undergoing a very similar reform. So Hong Kong will be an outlier if we don't follow the same policy. And I can say as a practitioner that we are facing daily requests from clients in terms of the demand for increased flexibility in the way in which we are able to structure fee arrangements for international commercial arbitration. So we are responding also to client demand, both here locally, across the border from mainland China, and internationally, as well as giving access to justice. So those are my two further points.
Chairman, yes, Ms. Khan, I would like to supplement. Now, here in LegCo, we are also talking about availability and use of resources. So if we make this law, if the litigants or if the party's behavior is affected, and also his choice of dispute resolution is affected, well, with the officer arrangement in place, some parties may be more inclined towards arbitration. Legal practitioners may be more inclined to work on contracts with clients. They may recommend to clients to go for arbitration because of the officer arrangement. So Hong Kong as a whole, how ready are we? So if LegCo passes this bill, on the whole, are we ready in arbitration, including the institution readiness or talents? Later on, perhaps we need to discuss court facilities. So relatively speaking, will there be some alleviation of demand on court facilities with this officer arrangement? That's my question, Chairman. Okay, so do you want DOJ's response? Well, if they have points to make, if they have any supplements, or perhaps the Bar Association or Law Society, based on the readiness of our talents, can you give some quick response, please? Okay, because of time constraints, I will see whether they have response. As for your second question on talents, perhaps you need to wait for your second round. Okay, so we'll see whether Mr. Chavez or other colleagues have anything to add.
主席，頭先第二個人才問題係咪喺下一輪
Chairman, on talents, do we want to discuss it in the next round? Okay, yes, next round. We don't have enough time. I don't have anything to add for the time being. Okay, LRC, any supplement to Ms. Khan's question? I have nothing to add. Okay. Well, Ms. Khan, nothing to add. Then you can ask your second question in your next round. Okay, Ms. Kong Yuk Foon, please. Thank you, Chairman. Let me declare, I am serving a council member of Law Society. In principle, I support this fee structure because to Hong Kong, I think, well, if we want to enhance our competitiveness, I think this point is very important. But apart from this fee structure, I think that on other areas, I think other supporting measures are also important. As Ms. Carmen Ken pointed out, for example, training of talents. In Singapore, for SIAC, they attach much importance to training of young lawyers, solicitors, and barristers in the area of arbitration. I want to ask the DOJ colleagues, I have read the bill, the draft bill. I have a few points to ask. So will these points be included in the future bill? First, concerning the execution of the fee structure agreement, who can enforce, where to enforce, when to enforce, and how to apply? Number two, let's say if a certain lawyer is deceased or if he is bankrupt, then will there be some impact on the fee structure agreement? Number three, if the parties change lawyers, then in the bill, I haven't seen anything on that. So in Singapore, I can see that in the law. These 3 points are included. So I wonder if the DOJ colleagues have anything to respond to. Thank you. Okay.
唔該，議員，多謝議員提問。係呢一度咧，其實去到呢個執行呢啲收費架構嘅一啲細節咧，正如頭先講會將會係呢一個附屬法例嗰度去交代嘅。咁始終咧嗰啲保障措施咧都係建基於咧其實係當事人同埋律師咧，其實可以自由商議咧，究竟應該嗰個收費架構入邊嗰個細則係乜嘢嘅。咁譬如頭先議員提到話究竟譬如幾時應該嗰個律師嘅錢係可以係需要俾咧？咁呢個都可以就係喺個條入邊應該列嘅。包括譬如係因為可能有時會有啲商咧就係咪真係要佢當事人實實在在贏曬收埋個錢落咗袋先至俾律師錢咧，先將個費用俾律師咧，其實就唔係嘅。正如法改會嘅報告入邊解釋咧，譬如喺 damages-based agreement 嗰個 context 入邊咧，都係講緊話當嗰個當事人取得嗰個 financial benefit 嗰個財務利益咧，都係講緊譬如話係當個 arbitral tribunal award 咗嗰個arbitral tribunal where it's already awarded the benefit, at that point it is already payable. The fee is payable at that point. And so these will all have to be specified when the two parties go into the arrangement. Now, the other question, let's say the client or the lawyer can at any time end the agreement, or the client can change the lawyer if he so wishes. And also in the bill, we would propose that if the lawyer feels that there is certain behavior of the client, he can also back out from the ORFSA. Now, just to take a bit of time concerning preparedness and education and training, at present, with this amendment bill, it is taking out the hurdle of not allowing offset, and then there will be safeguards put in as well. So it is actually a two-phased approach. There is a little bit of time. First of all, the amendment bill will come out. The ordinance will be amended with the ORFS allowed, and then with the subsidiary legislation coming out, and the two professional bodies will be changing and amending their professional codes accordingly, providing more directions, and then the DOJ at the same time will also be promoting Hong Kong's legal service, and education and training opportunities will arise there concerning how ORFS actually can be executed. So this is a time when the public and also the legal profession can gear up. Well, thank you very much for the response. We have two more members, and we would want to focus our discussions on the framework for ORFS, for subsidiary legislation relevant content. Perhaps we can wait for the next meeting. Yes, now let us have Ambrose Lam. Well, thank you, Chair. Now, first of all, we all know that for criminal legal procedures, what our procedures were based on, really, they are archaic and completely outdated. And I truly think that ORFS need to be introduced as soon as possible so that Hong Kong stays current and competitive. And also in the mainland of China, this is already commonplace. So this is already tardy in its arrival, but it is better than being absent altogether. And I also want to mention one point, and that is one theory goes that for the arbitration agreement, champerty and barratry should not be contravened.
as common law doctrines. My question is actually very simple. How many subsidiary legislations do we need to amend if we are to bring in our ORFS? That's a very simple question. Yes, DOJ, any response to Mr. Ambrose Lang, please? Well, we are
仲裁條例同埋法律執業者條例啦。咁
amending
然後我哋就會整一個附屬法例咧，去交代嗰啲保障措施嘅。咁所以係會即係整一個新嘅嘅附屬法例啦。咁係會整一個附屬法例出嚟交代嗰啲保障措施。
So there will be a subsidiary legislation pertaining to safeguards as well. Well, will there be other ordinances which need to be amended as well? For example, those pertaining to common law doctrines or championship, etc., or maintenance and barratry. Well, at present, as far as we can see, and with the help of LRC, in the main, it is the AO, the arbitration ordinance, and the LPO, legal practitioners ordinance, which are relevant. And that is why we want to, as soon as possible, remove these to pave the way for ORFSA. And then the safeguards will be contained in the subsidiary legislation. Well, in that case, I have a supplement question, because in 1997, with the amendment of LPO, lawyers are allowed to be operating on incorporated basis. Now, at present, there are still a number of outstanding ordinances which need to be amended because of that change. 130 of them, as far as I know, and that is why I asked a question that I did. All right, so the question was whether there are other ordinances which need to be amended. Next, we have Ms. Maggie Chan. Yes, thank you, Chair. For anything that helps Hong Kong to become or maintain Hong Kong as a leading arbitration seat and to increase our competitiveness, I'm all for it. As for OFSA, I have a question in principle. And it relates to increasing our competitiveness and also maintaining our professional conduct and professional practice. And what is that question? It is as follows. For OFSA, if you say that it is just a client and the lawyer, that relationship, the relationship between the two of them is easy to handle because we have the professional code of conduct. But in the process of OFSA procedures, if there is a non-legal practitioner and that is an outside party, which is basically just looking for business, and upon doing that, they link up the legal team, the lawyer's team, and the client. Now, in this kind of a situation, in the eye of the DOJ or whoever wants to respond to this question, now, if there is such a scenario, then non-professionals without professional conduct regulation, they may mess things up. That is my concern, because if you look at the market, there are certain consultancy companies, quote and unquote, who do not follow the professional conduct, and they basically attract the client first and then line up the legal professionals after. I do not want ORFSA to extend this kind of practice or malpractice into the arbitration field. Do you want any response from the, let's say, the DOJ?
明白嘅呢一類嘅 concern， 即係類似 ambulance chasing 嘅 concern， 其實喺個法國會嘅研究同埋報告咧都有睇到嘅。所以其實喺嚟緊嗰啲保障措施入邊咧，現階段喺一個報告入邊有嗰啲保障措施咧，已經係有幾樣咧都係個方向都係朝住就係要
and the direction is exactly to address this kind of concerns. For example, the ORFSA will have to be signed, it will have to be written, and that is signed by the client, and the lawyer has to inform the client of the right to take independent legal view, and also that the client will have to know clearly that he has a right to take independent advice. And the lawyer will have to tell the client that even with ORFS, the client is free to seek independent or another lawyer's advice, and the client has to acknowledge that he understands that. And also there is a minimum cooling off period of 7 days. And during this cooling off period, the client can choose to back out from the arrangement. So all these are attempts and efforts to address the issue that you have mentioned just now. But of course, in our future review, we can look into how we can provide further safeguards to the clients and also to the legal profession. No. Can I have a follow-up question, Chair? Well, because of the interest of time, you have to be very, very succinct. All right? In that case, my question is, will the law address the following? And that is, someone representing the lawyer and going into a relationship with a client, would the client and solicitor's relationship in this particular sense attract criminal liability? Okay. Well, Chair, at present we have not considered criminal liability in this area of practice. Well, Chair, I suggest that they do. I suggest that we should have such. All right. Next round of questions. And in the first round of question, actually, Ms. Khan, Carmen Khan, had another question, which we would want to invite the two professional bodies to respond to Ms. Khan's question, and that is concerning readiness of our people and professionals. And then we'll draw the line for the first round of questions. Shall we do that? So that's a second question asked by Ms. Khan, the two professional bodies. First of all, the Hong Kong Bar Association. Do you have any response to Ms. Khan, please? Well, thank you, Ms. Khan, for the question. Hong Kong, in this period of time, and in particular, during this time of COVID, we have put in a lot of measures to enhance our professionals, our colleagues' capabilities in arbitration. And we are therefore, given that, not worried about ORFS that we are proposing now. I don't think it will require a lot more training, and it has already been mentioned, or the questions asked, whether there are any other ordinances or indeed the Hong Kong Bar Association Code of Conduct need extensive changes. No, actually, and we are fully prepared. And yes, thank you, Chair. I am Eric Wu from the Law Society of Hong Kong. My response to the question is that we have the pool of professionals to receive ORFSA implementation. Now, as of today, the Law Society, we are very much a part of the arbitration scene, and definitely we will have sufficient talents and professionals to meet the need. All right, next we will have Ms. Kong. Doreen Kong, please. Yes, a question for DOJ. Now, with the OFSA, it is new to Hong Kong, and just now the DOJ said that there will be 2 phases of implementation. Now, this amendment bill only enables us to put in OFSA, and then for phase 2, there will be detailed clauses put in. Now, this is something completely new for FSA in Hong Kong. Will you be setting up, let's say, a work group or subcommittee, including DOJ colleagues, Law Reform Commission, and the 2 professional bodies, so as to, in the detailed implementation of OFSA, to make it smooth going? First of all, these bodies need to communicate among each other. And secondly, we really want to roll this out well. Now, let's say for title registration, we have working committees for that as well, so that in execution and in practice, the rollout would be better or smoother. So would you be thinking about that? That is in the second phase of your work to enhance communication by setting up this committee and for better rollout. DOJ, would you want to respond to that question? Well, thank you for the question.
我講得唔清楚，我講嗰兩期咧，講緊意思即係其實而家我哋修改嗰個大例啦，嗰兩條法例去撤銷嗰個禁止嘅規定，跟住下一步咧就係會做嗰個附屬法例嘅。點解咧？因為其實就係喺而家個條例草案入邊咧，係有處嗰個律政司司長咧有個權力咧係會委任一個諮詢委員會咧。去幫忙整嗰個 subsidiary legislation 嘅，咁所以嗰個配套咁所以其實而家就去因為法改會嗰個報告入邊咧，其實已經好幫忙咧，已經有一啲建議咧，就係話有咩類型嘅保障措施應該擺喺一個附屬法例度。咁其實我哋就係基於呢一啲嘅方向，就有嗰個諮詢嘅委員會成立嘅時候咧，就會即刻進行嗰個草擬嘅工作。咁所以我哋都
When will the subsidiary legislation be ready? Do you have a draft in place?
草稿當然就冇好似而家呢一個草案入邊嗰啲咁細節，咁但係就好似頭先講喺個報告入邊咧，已經係有一個 list of 嗰啲 recommendation， 咁就係要開始就係草擬真係個附屬法例。咁而家其實我哋都係會即係盡快係開展呢個工作。咁應該係即係點樣喺呢個年底之前都係會有即係一定有啲進展咁樣。但係我而家係有一個立法嗰個期喺度嘅。
Right. Even if we do not set up a committee or subcommittee, I hope that the Hong Kong Bar Association or Law Society can comment on the subsidiary legislation as soon as possible. Thank you. Right. So that's all for members' questions. Members, do you support this legislative proposal from the government? So colleagues, can we have gallery view so that I can see whether members have objection? Helpers, colleagues, is it okay to give me gallery view, please? Okay, let me see. No objection from members. Thank you. We will end our discussion of this item. Now, item 4, Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Bill and Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Rules. So I will invite representatives from administration and the professional bodies to turn on camera. So from the DOJ, we have Ms. Jenny Fong, Deputy Solicitor General Policy Affairs, Ms. Peggy Au Yang, Senior Assistant Solicitor General, and Ms. Annie Lee, Senior Government Counsel from Hong Kong Bar Association, Mr. Victor Dawes, Mr. Jose Antonio Morellans, Mr. Richard Kong, Ms. Kim Rooney. From the Law Society of Hong Kong, Mr. Nicholas Hunsworth and Mr. Mark Lin. They are both members of Civil Litigation Committee. Welcome. So now, this item includes a legislative proposal. So after the administration briefs us on the paper, I will invite the two professional bodies to give their comments, and then I will ask members to speak. So colleagues, please clear the raise hand signals. And if you have intention to speak, then please now press the raise hand button. Okay? And then government representative, can you go through the paper for us, please? Thank you.
呢條條例草案咧係落實咗香港特區同埋最高人民法院喺2019年簽訂嘅相互認可同埋執行民商事案件判決安排。而呢一個安排咧係與內地簽署嘅第9項關於民商事司法互助嘅文件
document
執
signed
行判
in
決
this
安排
area.
嘅簽訂咧，係回應
So
咗社會
the
嘅需
signing
求，
of the
目的咧
arrangement
就係
is in
減
line
少
with
與訟雙
society's
方
needs.
喺
The
兩地
goal
就住
is
同一
to
爭議重複提出
minimize the
訴
chance
訟
of
嘅需要，
repeated
令當事人嘅
litigation
利
by
益可
both
以得到
parties in
最
Hong
大
Kong
嘅
and
保
mainland
障。
so that
一
the
套有系
parties'
統同埋高
interests
效
can
嘅
be
相互認
well
可同
ensured.
埋執行
So
機
it
制，
is a highly
有利
efficient
於內地同
reciprocal
埋香港特
recognition and
區共同
enforcement
持續
system
發
or
展，
mechanism, and
亦
it
都有
is
助香港特
beneficial
區
to
作為亞太國
sustainable
際法律
development
同
in
埋
Hong Kong and China. It
解
also
決爭議
helps
中心嘅
Hong
定
Kong's
位。
development
執行
as
判
an
決安
international
排
and
嘅
Asia
擬定
Pacific
參考咗
dispute
當
resolution
時海牙
center.
判決公
So
約
we have
嘅
taken
草稿，
reference
同
from
埋
the
海牙
draft
判決
Hague
公約相比，執行
convention,
判決安
comparing
排
with
嘅
Hague
適用
convention.
適用於更
The
加多類
application
別
or the
嘅
scope
判
of
決，
application
除
covers
咗涵蓋涉及
different types
合
of
約同
cases.
埋侵權糾紛
Apart
嘅判決
from
之外，更加
judgments
明
on
確涵
contract
蓋咗
and
若干
tortious
有關知
disputes,
識產
it
權嘅
also
糾紛嘅判決。
incorporates
咁廣
disputes
泛嘅
on
適用
intellectual
範圍
property
係一項
rights.
重要
So
嘅
this
突
is a
破。
wide
喺
scope
香
and
港
it
亦
is a
係，而
major
香港亦都
breakthrough.
係首個
As
司法
such,
管轄
Hong
區，
Kong is the
同埋
first
內地就
jurisdiction
住相互認可同埋強制執
having
行
this
判決
reciprocal
有
recognition
如
and
此廣泛嘅適
enforcement
用範圍。
arrangements with mainland China with such a wide scope of
執行
coverage.
判決安排喺內地將會透過
So in
最高人民
China,
法院發出嘅
this
司法解
arrangement
釋落實，而
will
喺香
be
港就會透過
realized
條
by
例
means
草
of
案同埋
judicial
規則去實
interpretation
施。
by Supreme
就
People's
住條
Court
例
and in
草
Hong
案定
Kong
明嘅
by
登記
way
機
of
制，我
bill.
哋參考咗剛
And
生效
we
嘅
have
婚姻
taken
家庭
reference
判決
from
相互執
the
行條例第
matrimonial
639章，
law,
而呢一條條例
Cap
係以
639,
之前嘅第597章，即係內
and
地判
based on
決
Cap
交互強制執行條例，
537,
同埋第319章，
and
即係
also
外地判
Cap
決交互
319.
強制執行條例為藍本。
Well,
我哋
those
相
are
信
our
法律界、
reference
司法
points.
機
We
構同埋
believe
其他
that
持
the
份者
legal
對於
sector,
相
the
關嘅機
judiciary,
制
and
亦
other
都很
stakeholders
熟悉，
are already
亦
very
都具
familiar
備
with
咗一
those
定嘅經驗。
mechanisms, and they have
簡
already
單嚟
certain
講，喺
experience.
建議嘅機
So
制之
simply
下，
put, under the
當事人
proposed
可以單方
mechanism,
面向
the
原訟法
parties
庭提出
can
申請登記內地民商事判
apply
決，而
to
另外一方
register
面可以
the
就住法
mainland
庭可
judgments
以向
ex
法庭
parte.
申
On the
請
other
將
hand,
登記
they
作
can apply
廢。
to the court
除
to
咗某一
have
啲
the
規
registration
限
set
之外，
aside.
登記
Apart
範
from
圍咧
some
涵蓋咗金錢，
restrictions,
但係唔包括懲
the
罰性
scope
損害賠償
includes
同埋非
monetary
金錢嘅製作。已經
remedy and
登
also
記判決
non-monetary
可
remedy
以
with the
強制執
exception
行，
of
猶
punitive
如
and
原
exemplary
訟法庭
damages.
原先作出嘅判決一樣。
So it will be
條例
in
草
the same
案亦都
nature as
授權
judgment by
香港法院
CFI,
發出經
and
核
the
證
court
文
will
本同
also
埋
be
證明書，
authorized
利
to
便申請人喺內
issue
地
certificates
申請
so
認
that
可同埋
the
強制執
parties
行香港民
can
商
apply
事判
for
決。
recognition and enforcement of Hong
律
Kong
政司
civil and
喺
commercial
去
judgments in
年
the
嘅
mainland.
12月就
In
條例草
December,
案同埋
DOJ
規則議稿進
in
行咗一
relation
個
to the
半月
bill
嘅
and
公
the
眾諮
rules,
詢，
draft rules,
我哋一共
1
收
and a
咗
half
10幾
months
份嘅書面
consultation
意
has
見，
been done. We have
而
received
律
a
政
dozen
司
or
亦
so
都
written
同一啲
submissions.
持份者，
And
包括
DOJ
律師
had
公會
talked
同
to
埋大
some
律師公會
stakeholders,
會
including
面，
Law
介
Society and
紹咗
Bar
立法方
Association.
案嘅內容同埋
So
聽取佢哋嘅
the
意見。 整體
content
上，
of
大
the
多數回
legislative
應者
proposal
都係對
was
條例
being
草案同埋
introduced
規
and
則
their
表
views
示
were
支持。
taken. Overall speaking,
律政司今年
stakeholders
嘅
have
重點工
expressed
作之一
support.
係盡快透過
One
立法
important work of
落實判
DOJ
決
this year is
執行
to
判決安排。律政司
realize
計
and
劃喺
finalize
今年
the
嘅第二季
arrangement.
將條例草
So
案
in
提交
Q2
立
this
法
year,
會
it is
審
planned
議。
that the bill should be
至於
tabled
有
to
關嘅
LegCo
規則
for
嘅制
scrutiny.
定，
And
參
for the
考咗婚
relevant
姻家
rules,
庭判決相
after
互執
taking
行
into
條例嘅做法，
consideration
律政司會
the
通過
arrangement
喺
for
通過條例之
matrimonial
後，
cases,
透過
after the
先
bill
訂
is
立
passed,
後審議嘅程
so
序，
that would
將
be
規則
the
提
negative
交立
vetting
法會。
arrangement. for the rules to be tabled to LegCo. And during the period, DOJ will work with Supreme People's Court, so they will exchange views on the commencement date. In the interim period, DOJ will do public education work. For example, seminars will be organized. So with such public education work, before the commencement of the law, members of the public can be well prepared for the commencement of this law. So that's all in my briefing. Thank you, Chairman. Thank you, Ms. Fong. Now, let's invite representative of Law Society to comment. Well, Law Society has given members a detailed written submission. So now let's see who would like to speak from Law Society.
Yes. Nick Hunsworth,
Thank you, Chairman.
Law Society. Very briefly, members of the panel, the Law Society welcomes gladly this proposal for the reciprocal judgment of enforcement of mainland judgments. It's long overdue in our view, and we therefore welcome it. Our concern really is simply the manner in which this bill has been drafted. There is already in place mechanisms for the enforcement of judgments of certain countries overseas, which was in place before the handover in 1997. Since then, there's been a bill to enforce mainland judgments where the parties have agreed that their action can be the subject of enforcement. This extends the provision, but for some reason, the drafting, rather than following the previous legislation, has decided to go off in a new and rather different direction with different terms, and is a much more prolix and lengthy document than that which we lawyers are generally accustomed to in overriding legislation. So very shortly, we've put all the points in our written submission, so I don't propose to repeat them, merely to say that we would be delighted to embrace this bill, but simply would commend that the drafting follows the existing precedents in the legislation.
Thank you. Next, may I invite a representative from the Bar Association to give your comments, please? Thank you, Chairman. So we will have Mr. Hoey to speak on behalf of the Bar Association. Yes, thank you, Chairman and members. Let me very briefly explain our views on the drafting of the law. 5 main points. Number one, in the draft, starting from clause 10, it is stated that there is a registration order issued by the CFI of Hong Kong. So in other words, if there is a mainland judgment, and let's say you are the winning party of that judgment, in other words, you are the mainland judgment creditor. You come to Hong Kong and you want that mainland judgment to be enforced. So you can apply for registration order from CFI of Hong Kong. Once you get this registration order, then the mainland judgment will be seen as equivalent to a Hong Kong CFI's judgment, so that you in Hong Kong can have that mainland judgment enforced. That is the meaning of the registration order. And according to the draft, this registration order will have to be applied for within a period of 2 years. So let's say if there is a mainland judgment now, and there's the need for the losing party to do something within today. Let's say he may have to pay certain compensation. And if he does not do it today, then 2 years from today, he will have to make this application to the CFI of Hong Kong for registration order. Now, reading from the draft, this 2-year period cannot be extended. It is a final deadline. And we have given some comments to DOJ. So at the expiry of this period, will the CFI have discretion to consider exceptional grounds so that people can still make this application after 2 years? So we have taken reference from the matrimonial law, section 8b. The district court judge can have the discretion, even if the 2-year time limit has been passed. My next point is in relation to mainland judgments. What is the scope? Now we can see that in the bill, well, usually, even though the mainland judgment is a first trial judgment, if there is no appeal or let's say if the appeal period has already been passed on the mainland, you can still apply for registration order in Hong Kong to have enforcement. However, if in a mainland judgment, if the judgment includes two items, the first item is that the other party will have to pay compensation for a few 10 million. And the other item is to ask the other party to pay a certain amount of compensation plus the transfer of some shares. So in the mainland judgment, let's say, if the other party only raises one item in his appeal, then in Hong Kong, is it possible that for the item that won't be affected by the appeal, can enforcement still apply? So one more thing, let me explain briefly.
Now, let's say the unsuccessful party. If the unsuccessful party wants to cancel the particular order, then the CFI judge will have to decide when they will have to apply for the cancellation of the registration order. And so in this case, the mainland court, or rather the Hong Kong CFI, concerning this mainland court registration order, when this order is delivered to the party concerned, the date when the registration order is delivered to the party concerned, this date becomes relevant. So this is another view that we have forwarded to the DOJ. And a further point concerning punitive claims, and that is for mainland judgments which pertain to three situations, it can still be mandatorily enforced. One, IP infringement. Two, mainland anti-competition infringement. Third, commercial secrecy infringement. In the present draft, we do not see three commercial secrecy being mentioned. We hope that the DOJ will look into this. And the last point that we have as view is that for Hong Kong judgments, if it is to be enforced in the mainland, and that would include the Small Claims Tribunal, the Lands Tribunal, the Labor Tribunal, and the court's judgments of Hong Kong. But there are certain stipulations which seems to be unclear in the drafting as to whether the courts include the tribunals, such as the lands tribunals and the other tribunals that I have mentioned. Well, thank you, Mr. Hoey. Next is our question time. Because this is related to a legislating process, we therefore have other members joining in our discussion. I just want to mention at 4:47 p.m., the staff had already sent to you Ms. Priscilla Leung's letter concerning this item. Now, members, would you please proceed to speak? First of all, Mr. Ambrose Lam. Thank you, Chair. First of all, I am in support of this legislation, and I commend the DOJ in sidestepping that issue of the mainland courts being the finality of mainland judgments. I applaud that. Now, I have already given a very lengthy document outlining the views of myself and also the Lawyers Alliance to the DOJ, so I will not go into the specifics. Now, going back into 1997, and we have already discussed this, and that is mutual enforcement. I would like to know at present how many cases have already been given mutual enforcement since then. The DOJ, concerning statistics, perhaps my colleague Ao Yang can answer that question. Thank you, Chair. Thank you, Mr. Lam, for the question. I think your question pertains to the 2008 Cap 597 of the Hong Kong Ordinance, and that had come into commencement from 2008 onwards, and that's been quite a number of years since 2008, and that is concerning the implementation of Cap 597. We periodically report to the panel members on the progress, and this is usually provided by the judiciary to the panel. And in February of this year, as of February of this year, I think there have been 120 something cases of application under this. So after 2017, or rather in recent years, I see the number of cases increasing. And we can also see that for the mainland numbers, they are also increasing as well. And this is about the selection of courts, the choice of courts. Its scope is narrow relatively, and also there will have to be a clear selection of either the Hong Kong courts or the mainland courts on relevant disputes. And only then will there be this mutual enforcement validation. And now we are extending the scope of this for this round. So it is going to facilitate the users. It's going to be a lot more useful for the users. We hope that with the passage of this ordinance, there will be a full coverage of commercial and matters. Ms. Chan? Yes, thank you, Chair. Concerning the mainland judgments in civil and commercial matters reciprocal enforcement bill, I am in full support, and I want to see this commencing ASAP. From discussion to negotiations to putting into place, it's taken a long time, and time is not waiting for anyone. I have dual hats here. The mainland role as well. From statistics point of view, for Hong Kong application to mainland courts for enforcing Hong Kong judgments, they are few and far between. And I've been looking on the website in their documentation in the mainland. I have only found 20 plus cases since 2014 till now. And I want to see the commencement of this ordinance come into action as soon as possible, so that there is no retrials and lowering of costs, and the avoidance of relitigation and lowering of costs, and also the justice can be facilitated. And I think only then will we be able to really connect up the legal services of the Greater Bay Area. And at the same time, I hope the DOJ will, as soon as possible, implement this mainland judgments in civil and commercial matters bill, and to commence it as soon as possible. And after that, the it's not just about enforcement. This is an empty judgment. Empty judgments are not good enough, because at present we only have arbitration with its safekeeping. So I hope right after this, with the passage of this bill, before there are judgments, that there can be preservation of the properties of the parties concerned. Preservation of properties. Do you want an answer from the DOJ?
就住嗰個臨時製
Yes.
助嗰方面咧，
Well,
其實而
thank you
家咧
for
就係高
the
等法院條例
question
裏面咧，亦
concerning
都有一啲
interim
相關
relief. In the
嘅
High
法律程
Court,
序
there
咧，就
are
係可以
certain
俾當事
procedures
人去
which
運用嘅。
can
咁如
afford
果當事人咧就認為佢係
interim
需
relief
要
to the party
提出一
concerned.
個
If
司法
the
程序嘅
party
時候，佢
concerned
需
feels
要
that there should
去
be
申請一
certain
啲臨時製
legal
助咧，佢
procedures
係
to
有一個
apply
途
for
徑可以去
interim
做到
relief,
嘅。
there is a channel for so doing. Thank you. Other members who would want to speak on this particular item, please? If there are none, then I will have to ask members whether you are in support of this particular proposal from the government. I do not see any objections. All right. In that case, we will close the discussion of this item here. Now let us go to the 5th agenda item of today's meeting, which is the construction of a district court building at Caroline Hill Road. And again, because it is pertaining to financial matters, so we have members outside of the panel joining, and we have the 2 professional bodies and the government representatives attending. Would you please open the screen so that we can see you? First of all, we have the Judiciary Administration representatives, Ms. Esther Leung, Judiciary Administrator, Ms. Winky So, Deputy Judiciary Administrator, and also Francis Chang, Assistant Judiciary Administrator. And from the ASD Architectural Services Department, Mr. Frank Wong, Mr. Kevin Soon. And from the Bar Association, we have Mr. Victor Dawes, Mr. Moreland, Mr. Richard Cole, and Ms. Kim Rooney. And from the Law Society, Mr. Stephen Hong, Kenneth Wong, Mr. Dennis Ho, Mr. Kenneth Falk, and also Ms. Kelly Lam. Thank you for attending this meeting. Now, would the staff first of all, take away the hands raised, and would members who would want to speak, raise your hands later on. And as mentioned, there is a financial related proposal here before the government brings us through the paper. We will have first of all, the Department of Justice will bring us through the paper, hopefully within 10 minutes because of time. Well, thank you very much. And thank you, Chair. Thank you, members. The paper that we have here is basically to ask for your approval for the proposed construction of district court building at Caroline Hill Road. And basically, it is to provide for a new building to relocate and reprovision the district court, the family court, and the lands tribunal. We have consulted the 2 professional bodies. We have taken on board some of their suggestions, and also earlier in March, we have held 2 rounds of briefings for the panel, and we have suitably taken on board some of the views forwarded by the panel members at the briefing. And if you are supportive of our proposal at this meeting, we will be going to the Public Works Committee of the LegCo for support, and we will be within the and also seek the approval of Finance Committee. And the works will start middle of 2022, and commencement of the building will be in 2027. We will go through the briefing of the paper next. Thank you very much. Thank you, Chair. I will bring us through the design and also the timeline for the building. Now, first of all, the district court and the family court and the lands tribunal at present, and in particular where they are housed, and also the government's plans for the relocation of offices in the Wan Chai Tower, which houses the DC District Court and the FC Family Court. We will need, therefore, a new building to house these courts, so that the work of the law courts can be held in smoothly. And in particular, in 2015, starting, there had been a 14.5% increase in the overall caseload of the DCFC and LT in those 5 years, from 48,038 cases in 2015 to 55,010 cases in 2019. And also the two buildings had already in usage for over 35 years for housing the buildings housing the two courts. And it is already in saturation, and the facilities are limited, and they basically very much limit the efficiency of the courts in handling the heavy caseloads. And this is really, there is no time to waste in reprovisioning for and co-locating the three courts, that is the DC, FC, and LT, and to bring on synergies among them. Next, we will look at the location of the proposed facility. This is Caroline Hill. It is in the core commercial area. It is highly accessible with public transport connection, facilitating the users of the courts. It will be an independent building. It is in keeping with the requirement for the courts to be housed in an independent building so as to show the solemnity and dignity of the courts. And the new court building will be over 30,000 square meters in space, which is over 80% of the existing aggregate area of the three courts. And this will facilitate needed space for future development and expansion of the court facilities to serve the Hong Kong community. And there will be 100 parking spaces and 25 private parking spaces and 25 public parking spaces. And there are mini bus stations and bus stations, etc., to serve this building. And it is but 8 minutes walking from the MTR station. And the main access of the building will be provided with a covered access so as to facilitate the users. If you look at this plan, this is the preliminary design plan. It will be a dual tower. At the bottom of that would be an atrium, and the two buildings will be connected by way of a bridge, and there will not be any hindrance to ventilation, and the design also will mesh in with the surroundings, and we will also provide for the maintenance of an old and ancient tree on site.
Under appropriate circumstances, natural light will be used. So because of key need for room for courts and also more and more caseload, in terms of design and also ancillary facilities, chambers, the sharing of resources strategy is adopted so that there would be synergy in the operation of courts. Under these principles, the 70 courtrooms and 82 chambers of DCB will be shared by all three courts when necessary. And for ancillary resources and facilities, there will be multi-use facilities. There will be 70 courtrooms in the DCB, so an increase by 17 or 32% from now. And there will be 2 mega courts and also different sizes of civil and criminal courtrooms for different needs. So in face of increasing caseload and increasing complexity, there will be 82 chambers right now. Comparing with the 52 right now, there is an additional 26 and 46% chambers. And there will be some new facilities to be provided to enhance court service, including protected witness facilities. There will be independent access, elevator, and accesses. And there will be 28 criminal court exhibit rooms, designated mediation facilities, family court discussion room and also mediation breakout rooms so that members of the public can sit in so that transparency can be enhanced. In talking about ancillary facilities, sharing of resources will be adopted to make good use of the court space. There will be 28 witness waiting room, 45 consultation rooms, 3 video conferencing rooms, and 6 waiting room, and 12 mediation breakout rooms. There will be multi facilities for people's use. And then for ancillary facilities, apart from the registration office and also accounts, in terms of security, there will be centralized security check procedures to ensure safety of courts, court users, judges, and also judicial officers. There is security control room and also the police room in order to enhance security, in order to satisfy different court users' needs. And then there are facilities not available now in the court. These will be provided, for example, barrier-free facility, nursery facilities. And then a series of related facilities will also be provided, for example, visit room, robing facility, and also lawyers' common room, legal library, and also 1,200 letter boxes for law firms. For the media in the DCB, there will be press room with broadcast facilities. And then other facilities include information and also integrated information center for litigants. And there is also self-use service center that is automated. For crowd management, there are 12 high-speed, high-capacity elevators for the public, connecting different stories. Right now in the Wan Chai Tower, there are only 5, so there are 7 more. There will be escalators, so court users can reach the lower stories directly to get access to registration counter, accounts, and other commonly used facilities. For better crowd management, there will be a 600 square meter entrance lobby with queuing up area. And then there is also a covered loading and unloading area at the main entrance, and also an independent access, emergency access on Caroline Road West. So we are in close contact with the police. We will adopt the right crowd management and security measures to ensure that court operation is orderly and safe. We have consulted relevant stakeholders, the Bar Association, Law Society, Committee on Criminal Court Users and Civil Court Users, and also Family Court Users. They are all in agreement. And last year on this project, we consulted the Wan Chai District Council by circulation of papers. And then on the 11th of March, we already briefed the relevant panel, the AJLS panel. And we have taken on board stakeholders' views. We are now in the critical stage of this project. Now we are scrutinizing and considering the tender documents. After listening to members' views, we plan that in April and May, we will table the proposal to PWSC and ask for funding approval from FC. If everything goes smoothly, then in the middle of this year, the project can commence. And we hope that by the end of 2026, the project can be completed and DCB can be commissioned in 2027. Before the commissioning of DCB, Judiciary will try our best to increase court facilities. For example, within this year in Wan Chai Tower and Inland Revenue Tower, a temporary project will be carried out to add 7 more court rooms. So 6 district court, family court, and LT court rooms. So such work will start at the middle of this year, and it will be completed by phases by the end of next year. We attach much importance to this project in order to meet the long-term operational needs of the judiciary. We hope to get member support. That's all in my presentation. Thank you. Thank you, Judiciary Representative. Bar Association Representative, your comments, please. Who would like to speak from Bar Association? Thank you, Chairman. On this item, I will be giving my views. So the Bar Association supports this proposal. In the past, we had close communication with the judiciary. So concerning the details of the new building, we have given our comments in writing and also in a number of meetings. So here I would like to say very briefly that I know that many LegCo members are members to the two professional bodies, and I believe the legal profession agrees that existing facilities are very inadequate. They cannot meet society's needs. If we compare with neighboring countries like Singapore, we are very backward. So for this proposal, I don't think it can be delayed further. So I hope that the relevant arrangements can take place as soon as possible. Besides, now the next point is related to the pandemic. I believe the judiciary has considered the request of Law Society and Bar Association in relation to remote hearing, and we have talked about the undesirable points right now. I hope that the DCB will not only serve short-term needs. We can think further ahead about future trend. We hope that all courts can have remote hearings for both civil and criminal cases. I know that this proposal may be involved in other bills as well, so I won't repeat my points. So that's all from me for the time being. Thank you. Right, Law Society representative, please. Chairman, good afternoon. I am Stephen Hong. The Law Society of Hong Kong has already submitted our comments to the judiciary. I will not repeat the points made there. I do agree that since a new DCB will be built, well, concerning the hardware, especially the hardware that will facilitate remote hearings, I believe the judiciary needs to spend more time on that. Of course, I don't want to see that 4 to 5 years later, yes, there is a new court building, but in terms of technology, well, this is not possible, that is not possible because of not enough sockets and so on. That will not be desirable. My last point is about car parking spaces. In the presentation just now, it is said that there will be 3 video conferencing rooms. When you say 3, do you mean 3 each on each story, or there are only 3 for the whole building? If there are only 3 for the whole building, then I don't think that will be enough. Then in terms of car parking, there are 100 car parking spaces. But for spaces available for lawyers, how many are there? Of course, I don't want 95 spaces to be available only for the judicial officers working in that building. And then for lawyers, solicitors, and barristers, they need to fight for the remaining 5 spaces. Concerning construction, well, can there be a plan? For example, can there be a plan showing the allocation of rooms on each story? I hope the judiciary can contact the Law Society and Bar Association and let us have a look of the plan to see whether users can have any further suggestions. Thank you, Chairman. Thank you, Mr. Hong. Now it's time for members to ask questions. If you want to ask questions, please raise your hand. Before you speak, let me remind you, members, if you have direct or indirect pecuniary interest, then in accordance with number 83, capital A, please declare or disclose the nature of your interest, and please refer to procedure 84. In case of direct pecuniary interest, please note the voting rules. Mr. Tommy Cheung, Mr. Lam Sun Keung, and Mr. Holden Chow have raised their hands. So let me invite Mr. Tommy Cheung first, 4 minutes. Thank you, Chairman. We don't have too much time. I understand that the users, including Law Society and Bar Association, the government, they have different views. If possible, well, I hope the construction progress will not be hindered. Well, that site is not really very big. It cannot really accommodate a lot of things. The Liberal Party is in favor of this funding proposal. So we support the tabling of this proposal to PWSC and FC. So that's all from me. No need for any response. Next, Mr. Lam Sun Keung. Thank you, Chairman. In the presentation just now, so by the end of 2026, the building will be completed. So in other words, 4 years after funding. For e-filing, it has not been in place after 10 odd years. And for Twin Towers, well, they will be completed in 4 years. Of course, I hope that can be done. Recently, because the pandemic is very severe, as a result, the courts have come to a semi-halt, so to speak. But then the court is not taking in filing because there is no e-filing. So there are many problems with solicitors and barristers' case. So my question is about this agenda, okay?
And because of this situation, I would like to know, with this 4-year of construction period, I hope you will have periodic reports to this panel so that we can provide proper monitoring and supervision. That's my request. Any response, please? Thank you, Chair. And I would want to thank Mr. Lam for the question. In this court building, we project that there will be a 4-year construction period. If we start this year, 2022, it will be, if everything goes well, we will complete that in 2026 and commence usage in 2027. As for the e-format in handling court documents, in fact, it is already being put into place in phased approach, but because of COVID, we have been slightly tardy in kicking it off. And for civil litigations cases, we hope within this year, we will be able to cover the civil litigations in the district courts for documentation within the year. And then we will be progressing to the magistracies, the summonses, and then we will move on to the High Court. So we do not have to wait till the completion of the new court building before we implement documentation of legal papers. And another point is that if we can use other methods to handle written documents and also remote hearing during this COVID period, we will use such formats as well. Chair, actually, my question was really about periodic report to this panel concerning the construction of the court building. Chair, yes, we can consider coming to the LegCo for periodic progress report. Next, we will have Mr. Holden Chow. Thank you, Chair. First of all, I am in support of this new court building, and I want to see it completed as soon as possible. In the briefing, a question comes to mind and which I have raised, and that is because the COVID situation is still rampant, and we do not know how it will pan out and whether there will be a 6th wave of COVID. And when it comes to this kind of projects, the authorities will have to take that into account as well. And that is possible delay because of new waves of COVID, leading to delays in the construction. Of course, we would want this to be completed on timely basis. So that is my point on timetable or timeline. Second point from me, and that is, in the document from the government, it mentions that for this new court building for FC, I see certain mention of the FC and also mediation for family cases. In the past, because of lack of facilities and rooms for mediation, and therefore the mediation processes for FC had been hindered. Now I do see a number of rooms being provided for matrimonial and family proceedings. And how did you come up with this number of rooms for mediation, first of all? And secondly, can you consider bringing on these facilities sooner on the completion of the building, so that, let's say, the parties concerned can find their mediators as soon as possible, and therefore to speed up with the process of mediation for family proceedings. And I'm sure you want to lower the cases of family proceedings through encouraging and facilitating mediation. Can you talk about mediation a bit more, please? Well, thank you very much. Mr. Chow is concerned, first of all, about the timeline. Yes, we will take your view on board. We will be working with the Architectural Services Department. We are taking the mode of design and build for the building this time, so that the design and the construction can go hand in hand, so that it is more cost effective and efficient in terms of construction time. Second point concerning the FC, in the court building, the extension of facilities for FC is very much emphasized. Apart from JJO offices, also it is there will be more provision for mediation rooms and also hardware. And whether the number of rooms that we have proposed is indeed sufficient, that's not a science, but rather I can say that compared to the existing provision, it is much better. At present, we are already going the coordination mode, and that is the law courts will work with the judges of the courts, and where they find that certain cases are fitting for mediation, we will refer them to suitable mediators. With more of these rooms for discussion and mediation, it will extend the service. So this is not just about the cases, but also pecuniary disputes arising from FC cases, and for situations that do not need to go to the court, really, they can also be dealt with in these facilities as well. Two more members have yet to speak. Let me just announce that we will extend this meeting by 15 minutes. First of all, Ms. Carmen Kan. Thank you, Chair. I speak to support the proposal for the construction of a district court building at Caroline Hill Road. I see that for our 3 items discussed at this meeting today are very meaningful indeed, and they are related. First of all, OFSA and promoting arbitration in Hong Kong, and secondly, reciprocal enforcement for mainland judgments in civil and commercial matters. And this is a jurisdiction which can provide this kind of reciprocal enforcement vis-a-vis China mainland judgments. And in the court building, together with the 2 very important developments that we have mentioned and discussed in this meeting just now. And today we have everybody here. We have the DOJ, we have the judiciary, and we have the 2 professional bodies, and that is good. Now, concerning the advisory committee for OFSA, while it has been set up, I also urge that you listen to more views, panelists here, the two professional bodies, and other related parties to listen to their views. And I would want to thank the judiciary in saying that the construction of the court building will be expedited or will be going full steam ahead, and also with OFSA in the future. And Mr. Hong of the Law Society had spoken as well concerning the situation. They are in support, and the yes, and the Bar Association, of course, is also in support. And overall, the three items together would bring us the judiciary and the practice to the where it is in terms of development and time, where it should be. I don't need a response to that. It's not a question. Mr. Liu Cheng-Kong? Yes, I'm in support of the proposal. I just have a question concerning the district court building. And this is in response to the reprovisioning for the DCFC and LT with its increasing caseload. And in terms of square meters, it is 30,160, and it is 17 more courtrooms, reaching 70 courts in total. I would like to know how you come to this particular number. Do you have any appraisal as to whether this is a sufficient number of courtrooms and whether it would shorten the queue for cases going to the courts for trial? And secondly, for the family courts, only 3 of them have independent access and waiting rooms. But for FCs, the partners or the husbands and wives are very often in adversary situation. And there had been situations where, in particular, the woman had been attacked right outside of the court. So for this independent access and waiting rooms ancillary to the FC, how are they being provisioned to lower this kind of violent incidents? Now, I see that the completion is projected to be in 2026, and then installation and testing will take 1 year. My question is, why a long 1 year for installation and testing? Can that not be expedited, please? 3 questions, please. Thank you, Chair. Thank you, Mr. Liu, for the questions. Concerning technical issue, perhaps architectural services colleagues can answer the question. According to my understanding, there's over 30,000 square meters. It is already maximizing on the plot ratio to accommodate all the facilities that we intend to put in there. Now, after the completion period, it will take about 12 months before commencement of use. And that is based on previous example, including the West Kowloon building. Its floor area and is actually much smaller. It's actually just 50% of what we have here, and they needed 12 months. So or thereabouts. Yes, we indeed want to compress the installation and testing time wherever we can. The other question was that for the 3 courts in the past few years, for the district court, family court, and lands tribunal, their caseloads had been increasing significantly. Starting from 2015, it had been 14.5% increase in the 5 years since. And the caseload increase had stabilized, and there may be a retraction or decrease, but that may be temporary. Now, for district courts, the cases are getting more and more complicated, and they take more lengthy trial periods. And we have taken that into account in the extension of district courts, and that has increased 30%. And the judges' offices increased by over 40% in terms of floor area. And we hope that we will be able to accommodate more cases. And in the new building, we will be maximizing on the use of IT. And in particular, for civil cases, they will be using more remote hearing, etc. So not all the trials need to be, or hearings need to take place within the courtrooms. And the other point is that for the 3 video conferencing rooms, it is not true that only they can sustain remote hearing, but all the basically all the dozens of courtrooms and interview or conference rooms, we will be deploying IT there as well. And it will not be because of technical restrictions that we cannot conduct, say, remote hearing format, for instance.
There will be 3 separate waiting rooms for the 2 parties to use, but then if there is the need for more than 3, then we can use other consultation rooms for the same purpose, because the design concept is that we are co-sharing resources. I would like to ask the ASD colleague to talk about full use of plot ratio and also time required for commissioning the DCB. Okay, anything to add? Right. The planning department had revised the OZP. So in terms of the plot ratio and the total GFA, well, basically we have reached 99% almost for plot ratio. So 6.6, we are at 6.52 already. And then for upper limit of GFA, we are almost 90% right now. Okay. Any other members who would like to ask questions? If not, then do you support the administration for tabling this item to PWSC for consideration? I don't see any objection. Okay, so now I will conclude this item. Item 6, any other business. If there is no AOB, then I will declare that this meeting is adjourned. Thank you. Meeting adjourned.